Law&Crime's Daily Debrief, everybody. And breaking news just into the Law&Crime network right now. Actor Jussie Smollett has been indicted or accused of 6 counts of disorderly conduct by a special prosecutor. This comes long after Chicago prosecutor Kim Foxx refused to go forward with a case against Smollett related to an alleged racist and homophobic attack seen here, which he said was perpetrated on himself in that city. Police accused Smollett of lying about the attack. Smollett now due in court on this case February 24th. We will closely monitor that one for you. The defense has rested and the state has wrapped up a brief rebuttal in the sex crimes trial of Harvey Weinstein. Law&Crime's Jesse Weber has been in court for much of the trial. He reports on what happened today and where the case goes from here.
Into the next chapter of the Harvey Weinstein trial, we heard from the last defense witness, a man named Thomas. He was a friend of Jessica Mann. You'll recall that Jessica Mann claims that she was raped by Harvey Weinstein in this hotel and then went to a breakfast afterwards with him and Thomas. Well, Thomas, who testified for the defense, said, in his opinion, she didn't appear to be out of the normal. She never said that she was sexually assaulted. Her hair was fine. Her complexion was fine. Nothing seemed to be out of the ordinary. We then moved into a waiting game. About 15 to 20 minutes were given by the court for Harvey Weinstein to have a conference with his attorneys to determine if he was going to take the stand. He comes back into the courtroom, and Damon Chironis indicated to the court that he will not testify in this case. We had an opportunity to hear from Arthur Aidala outside of court at the conclusion of this morning session. Here's what he had to say.
Mr. Weinstein has been a very good client. We didn't have to restrain him, but he was ready, willing, and able and anxious to testify, to clear his name, to clear the facts of these cases. But Mr. Chironis and Ms. Rotuno, joined with the rest of the New York team, advised him that he did not need to do that because the evidence presented in this case was anemic at best. If his name was not Harvey Weinstein and it was John Doe, the Manhattan District Attorney's Office would have never brought these charges. The prosecutor has failed miserably to prove their case beyond a reasonable doubt. So he did testify on a couple of occasions when he stood before different judges and said, I am not guilty of all of the charges against him.
The jury was dismissed for the day. They're going to come back on Thursday because that is when we are going to have the closing arguments, first by the defense, possibly by Donna Rotuno. Friday will be the closing by the prosecution, delivered by Jonah Luzzi. Then the following Tuesday, the jury will be handed those jury instructions. They'll be read the jury instructions and go into their deliberation. In front of the judge, there was a bit of a fireworks when the suggestion was made by the prosecution that they want to mention perhaps the walker in their closing argument, and they indicated that they used the word prop. It was at this point that Damon Chironis jumped up and said, it's not a prop. There was a fight back and forth. The judge said, don't mention it in your closing. And now we're moving into the conclusion of the Harvey Weinstein trial. I'm Jesse Weber, reporting for Law&Crime.
Weinstein's publicist also spoke after court, further explaining Weinstein's decision not to take the stand.
Harvey has been wanting to tell his story, to tell his narrative, to get his side out for a long time. In the end, we didn't need to do it, and it wasn't the right forum.
And how was he convinced not to do that? Because he is the client.
I think he heard the same evidence you all heard in the courtroom, and ultimately the state didn't meet the burden, and I think he knows that.
Attorney David Ring represents one of the women Weinstein is accused of sexually assaulting in Los Angeles. Ring spoke with me earlier today when we learned Weinstein was not going to take the stand in his own defense and said had Weinstein testified, it would have been a disaster.
Harvey Weinstein was never going to testify in this New York criminal case. Nothing good would have come from Harvey Weinstein taking that witness stand. He would have been absolutely destroyed by the prosecutor. So truly, I think it was a big act. If that's what happened in the courtroom where Weinstein tried to make it look like, oh, I want to take the stand, and they're having some argument with his attorney. No, you can't take the stand. That's a prop, just like his Kane and Walker are props. Oh, I mean, come on. Look, if he gets on that stand, you have 6 women you can question him about for days. about his interactions with those women and his statements about, consent and not consent and his bullying power. And I'm telling you, that prosecutor was ready to go with Harvey Weinstein on the stand, and he would not have survived it. It would not have gone well. And frankly, I don't think he's a likable person. And I think the jury would have been reinforced in their dislike for him if he gets on that witness stand.
Let's bring in now the 4 attorneys watching with us tonight, starting here in New York with Brian Wagner and Linda Kenny-Bodden. So, Linda, apparently they had to restrain Harvey Weinstein to prevent him from leaping up onto the witness stand and telling everyone his side of the story. Do you buy that?
I think his attorneys did it through cross-examination. That's his side of the story. Now, what was happening in that room, there was either a court reporter, stenographer, whatever, they were taking down. They were telling him the advantages, disadvantages of testifying, making sure that when he said to the court he didn't want to testify, that the attorneys had already gone over that with him and that was his decision based on their advice. No doubt.
Ultimately, it's his decision to make. His attorneys can counsel him. And here, apparently, they won if we're to listen to the version of it we heard outside court there from Martha Rydella. Brian Wagner, did the state prove its case beyond a reasonable doubt? This whole thing saying he has a story to tell, but he's not going to tell it because he doesn't think the state proved its story.
I don't think the state met their burden beyond a reasonable doubt. And I don't think Harvey Weinstein would have been served by testifying I don't think it would have helped him at all. I think it would have just turned the jurors off.
All right, let's turn to our other guest tonight, Stephen Mulroy in Memphis and Dina Dahl in Los Angeles. Dina, do you believe Brian's correct here? Do you think the state proved this case beyond a reasonable doubt thus far?
I think it's possible. The 2 accusers, obviously there's some issues and there's going to be a question of credibility. But the fact that there were 6 women all talking to a pattern is going to help the prosecution quite enough. And Harvey Weinstein, the ultimate storyteller, is going to have to really tell a good story during his defense because I think the prosecution brought a lot of good evidence.
Exactly. Okay, Stephen Mulroy here. The Walker as a prop. No chance to bring that in during closing arguments. What's your assessment of that?
I think it was probably a sound decision by the trial judge. There is a potential for it being inflammatory and prejudicial to the defendant, and it doesn't really have a whole lot of probative value. So it's no great sacrifice for the prosecution not to be able to mention it, and it eliminates a risk, even if a minor risk. That's the kind of thing that could be brought up on appeal to get a retrial. On balance, I think if I were a trial judge, I might have made a similar call.
Good analysis tonight. Let's head now to Ohio, where the state presented critical DNA evidence against a man accused of raping and murdering a young woman there. Anthony Pardon is accused of stabbing and strangling Rachel Anderson on her 24th birthday. The lead detective discovered her debit card was missing and started tracking it. A panhandler named Anthony Sleet used the card as seen here in store security video. Sleet told police that a man presumed to be the defendant approached him and asked him to start taking suspiciously large amounts of cash out of ATMs. Sleet became shocked when he was told the victim was dead. The defendant's sister testified off camera that she used that debit card to make purchases at a shoe store, a grocery store, and even at a casino, all at the defendant's direct request. She says the defendant told her the card belonged to his girlfriend, Bernita Anderson, even though the sister said the card contained the victim's name, Rachel. Also this week, the defense said the defendant's cell phone was near the victim's apartment because that is where Bernita Anderson also lived. The defense has attacked a witness's credibility about who testified about that debit card, and the defense has raised the issue of a nearby girlfriend to explain away the defendant's phone near the murder scene. However, it's harder for the defense to refute the results of a sexual assault kit which placed the defendant's DNA in and around the victim's private areas.
The YSTR profile from the sperm fraction of 002A1, which were the vaginal swabs, is consistent with the YSTR profile of Anthony Pardon.
Okay. Do we have the same kind of number there, statistics?
Yes.
The same 0 in 5,305?
Yes.
And again, to you, that's what you mean by cannot be excluded? Am I mixing those up?
The statistic is to support the inclusion.
So you said the sperm fraction of that vaginal swab was consistent with the defendant's YSTR profile. Did you draw any other conclusions from those vaginal swabs?
Anthony Sleet can be excluded as a contributor. The partial YSTR profile from the epithelial fraction of 002A1, which for the vaginal swabs, is consistent with the YSTR profile of Anthony Pardon.
Okay. Also excluding Anthony Sleet?
Yes.
The state found the defendant's DNA on other items as well, such as the curling iron cord and the hairdryer cord used to bind the victim. The defense wanted to be more explicit, though, and asked whether the state found the defendant's sperm anywhere.
I believe I did not find spermatozoa on any of the items that I tested.
So tell them what that means. None of Anthony Pardon's sperm was inside of Rachel, on Rachel, or anything else. Is that correct?
The only spermatozoa that was found would be on the bathrobe, and that was consistent with John Anderson.
Okay, so my question is, so the jury's clear, none of Anthony Pardon's sperm was found on Rachel Anderson on her body, inside or out. Is that correct?
I did not find any spermatozoa on the items that I included Anthony Pardon.
Ms. Simon, you don't want to say that you didn't find none of Anthony Pardon's sperm? You don't want to say that? You don't want to say that?
Well, I didn't find spermatozoa on the items that I included him as a contributor.
Let's turn to our panel once again right now. Dina Dahl in Los Angeles, Stephen Mulroy in Memphis. Stephen, we're getting into more graphic testimony here, but the bottom line is the state's trying to prove a rape and murder beyond a reasonable doubt. Is this back and forth? There's DNA inside the victim, sorry to be graphic, but no sperm cells inside the victim. Does that draw a distinction? Does that make an ultimate difference here?
Well, I don't know how the defendant would explain any DNA from the defendant being inside the victim absent some sort of intimate relationship, unless they're claiming that it wasn't in fact the defendant's DNA and there was a mistake in the methodology of the DNA identification. So, you know, the lack of finding sperm, again, anything could go towards a reasonable doubt. You only need reasonable doubt on the mind of one juror. But I do think the fact that they don't have any explanation for finding some DNA inside the victim is going to be a problem for the defense.
I think so too, Dina. I think this is a strong case for the state. I know the defense tried to explain away the debit card evidence in some way, tried to explain away the phone evidence in another way, but the DNA evidence, I don't think the defense has a good way to explain.
Exactly. I think, like you said, they've tried to explain away all that other evidence, not at such a great job, I don't think. And then even the DNA evidence on the cords. I mean, he was trying to say he had a relationship with her, but there's absolutely no reason that your DNA would only be found on the methods of actually tying her up. If I'm on that jury, the prosecution is going to convince me to convict.
I think so as well. Let's turn in-house here. Brian Wagner, you're nodding your head in agreement with my other panelists tonight.
Yeah, I think Dina makes a good point. The defense is not a magician. They can't make all the evidence disappear. And even if you cause some reasonable doubt as to one piece of evidence, the debit card and the cell phone corroborate that he was the one that did it. So you can't make all the evidence disappear.
Linda Kenny-Bodden.
I think it's a great case for the prosecution. However, having said that, you have one juror who says, hey, you led me to believe that there was sperm inside her, that she was raped and then he ejaculated, and excuse me for being graphic, but that's what's going to happen. And then they come out and it turns out there is none. If they talk about sperm fractions, someone could say, hey, wait a second, what's going on here?
It's a possibility. I mean, the other way to turn around is say, there's other ways his DNA could have gotten inside there. There could have been a sex act. It just didn't result, again, to be graphic, in what you said. I'll just put it that way.
Exactly. And that's what they'll be talking about in the courtroom.
Exactly. Okay. Still ahead tonight here on the Debrief. Jury selection underway in an Iowa cold case dating back some 40 years. Plus, closing arguments in the killing of a young Dallas mother by an on-duty police officer. Is it justifiable defense of another officer, or is it a criminal act? The final arguments of both sides are straight ahead. Selection today in a cold case out of Iowa. Prosecutors in Cedar Rapids say Jerry Burns, now 66 years old, murdered then 18-year-old Michelle Martinko back when Burns was 25. The December 1979 killing went unsolved until DNA tests in 2006 were re-examined using 2018 technology, and detectives finally settled on a suspect whose DNA they collected from a discarded straw at a pizza place. Authorities say Martinko was stabbed at least 8 times in the chest and face. They first thought the crime was committed by someone the victim knew due to the personal nature of the injuries. It's believed, however, now this defendant did not know the victim. The DNA evidence against that defendant came from blood the presumed killer left on the victim's clothes and on the gear shift of the vehicle where her body was found. And finally tonight, to testimony in the trial of a Dallas police officer who fired his weapon while on duty and killed a young woman. Officer Christopher Hess pulled the trigger 12 times, ending the life of 21-year-old Genevieve Dawes. The charge he faces is aggravated assault by a public servant, and it carries a possible 5 to 99-year prison sentence. Dawes and her partner tried to flee when police tried to investigate whether the vehicle they were sleeping in was stolen. During a brief rebuttal case, a state expert recreated how fast the vehicle was driving.
3 miles an hour, and I believe just short before I think it was average velocity of about 2.8 miles per hour. We always try to work with average velocity to be more meaningful. So in this case, the velocities are in fact low, and they're within the what are the parameters of human walking speed. So as we're looking down, you'll notice the velocity of the Dodge is in the upper center of the screen. Now it's just started backing up, and it strikes the patrol car, and it's going to go forward into the fence. Now it's going to back up the sequence, and you'll see that the first shot is now 4 seconds away, 2 seconds. So the car stops after the first shot are fired, and then it rolls back again. And you can track the velocity throughout the motion by just looking at that scene.
The state told the jury it must focus on whether the officer's actions were legally reasonable and said an ordinary person would not have used that same level of force.
Does that mean that their lives are more valuable than ours? Sure sounds like it to me. But I can tell you what, she had a right to go home. She had a right to go home that night. They deserved it is not an excuse for taking a life. The fact that a gun was found in this van has no bearing on anything. That is simply a mechanism to get you guys to feel okay with justifying killing this person. If Officer Hess didn't use his weapon, she would have killed everybody with that gun. That's what they want you to think. The reality is it had no bearing on anything.
The defense went back to the legal theory that Officer Hess was justified when he pulled the trigger because he thought he was defending his partners on the force and possibly even himself.
What would a law-abiding, upstanding, not committing crimes, not scared of what you're going to find in this vehicle, not scared of what punishment I'm going to be looking at because of my actions that led them to be here to begin with, wouldn't have rolled down the window and stuck out their hands? And if you've been on the force, I don't care whether it's 10 days or 10 years, your apprehension level, and you're going to be sitting there thinking, just like Joe Samples, Joe Ordinary Citizen, was. What are they hiding? Why aren't they complying with the commands?
Let's turn to our guests one final time tonight here on The Debrief. Dina Dahl and Stephen Mulroy are with me remotely. Stephen, when you look at that recreation of the video, 2.8 miles an hour, and then we hear the officers saying that the vehicle was fleeing, that the vehicle rammed their squad cars, does what the officers have been saying match up with the actual recreation?
Doesn't appear to match up with the recreation, and based on the recreation, there's some serious doubt about the justifiability of the use of deadly force. You know, the use of deadly force is only allowed when the officer objectively, reasonably believes that it is necessary to prevent either himself or somebody else from serious bodily injury or death. The mere fact that they may have been attempting to flee by itself doesn't justify the use of deadly force. So you have a very, very slow vehicle that might have bumped into the car at one point and then was backing away rather slowly at another point. That doesn't necessarily mean that the officer can leap to the conclusion that the person was about to apply imminent deadly force that would have caused serious bodily injury or death to himself or one of his fellow officers.
Dina Dahl, do you agree or disagree?
You know, I agree. I think that they made a great prosecution statement of why isn't her life just as important to the police's life? I mean, it's not ideal that she didn't do exactly what the police asked her to do, which was, you know, stop and put her hands out the window. But does that justify shooting 12 times into a car, most likely killing the passenger? It has to be no.
All right, appreciate the insight there, Dina and Stephen. I know we're just about out of time here, but I do want to turn to my guests here in studio. So Linda and Brian, here's what bothers me about this. Brian, when I listen to that recording, I hear all these commands being yelled at two people sleeping in a vehicle, and then we hear someone scream out, back up, and it's at that second when the car starts to back up. And I didn't see all of the closing arguments, but it bothers me that the prosecution didn't really latch on that, because to me, that's the entire case. You startle two people, you start yelling, put your hands up, and then you start saying, back up, back up, back up, and then they do it, and then you say freeze and open fire less than a second later. That's the issue.
And that's the point, right? No one doubts that the officers were scared. They were. The question is whether or not they were reasonably so scared that they were allowed to use deadly physical force, and that's what you're talking about.
And Linda, so when I look at that, I would turn around, if I were the prosecutor, I would let the video tell the entire story and say, look, you just heard everybody's opinion about what happened here. Look at what actually happened. The video tells its own story. The people in the vehicle, once they were able to pay attention to what was happening, the command was followed. It was probably a command to other officers to back up, but the people in the car could have reasonably believed that that meant they were to back up. They start to back up, and then one of them died because of it.
Aaron, you were absolutely right. As a matter of fact, when I was looking at that recreation, I think the prosecution on the rebuttal missed an argument. They could have said, they ended, remember, the defense ended and said, all she had to do was obey the commands. Ladies and gentlemen, she did obey the commands, and because of that, she's dead.
Okay, in 2.8 miles an hour, I mean, it seems to me that even if officers are scared, and look, I realize they saw shadows in the car, they didn't know if there was a weapon, they believed it could have been stolen. Look, fears are being heightened, but this car was not speeding 60 miles an hour down the road at a group of officers.
And they're trained to supposedly discern the difference. And remember, after the shots are fired, that's when the officers say shots fired. It's because they fired the shots, not the people in the car.
Exactly.
There is a lot to deal with.
Out of time tonight. Appreciate the insight here on the Debrief. I'll see you back here tomorrow at 5.